Hello, everyone, and welcome to the training for volunteers at Citizenship Workshops. We are going to talk about how to complete N400 citizenship applications. Now, you might be a volunteer at an upcoming workshop organized by One America, or by the City of Seattle New Citizens Campaign, or by another organization. So your specific procedures might vary slightly, but this training will go into depth about how to complete the N400 form and a few other things. Here's what we're going to go over today. First of all, what to expect at a typical citizenship workshop, the benefits associated with applying for citizenship, as well as some of the barriers, the legal requirements for U.S. citizenship. We'll just touch briefly on basic eligibility requirements, as well as some red flags to look out for and who should really not apply for citizenship. And then finally, we're going to spend the bulk of our time on how to complete the N400 citizenship application. It might be wise if you have the N400 form in front of you, as well as the intake and screening form of the workshop that you're going to be attending. However, it's not necessary. We're going to show screenshots of the forms here in the training. But if you have them in front of you, or you can open them up in a separate window in your computer, they may be helpful. So what is a citizenship workshop? Well, it is a day-long free legal clinic designed to legal permanent residents, also known as green card holders, successfully apply for U.S. citizenship. These were actually started here in Washington State for the first time by the American Immigration Lawyers Association of Washington back in 2004. Since then, the program has grown. One America hosts several of these workshops per year, so does the City of Seattle and many other organizations. And to date, we've helped probably more than 10,000 people at these workshops since we began more than 10 years ago. These events would be completely impossible without volunteers. Any workshop that you go to will have a crew of 25 to 100 volunteers who are in charge of running all of the stations. That includes immigration attorneys, nonprofits, legal advocates who are known as Department of Justice accredited representatives, volunteer interpreters, and trained form fillers like yourselves, as well as other event staff. Now we'll talk about what you might be able to expect at a citizenship workshop. You'll want to pay attention to the email confirmations that you received from your site organizers for the exact times that you need to arrive, because that may vary depending on the workshop. We really recommend that you eat a good breakfast before you arrive and take a break after you receive your morning training, because the forms station tends to be really busy around lunchtime. And the reason is because attorneys have to screen the first round of applicants, which can take anywhere from 20 minutes, sometimes up to an hour. And you will receive your applicants to start filling out the N400 only once that screening is done. Your citizenship workshop might be appointment only, it might be walk-in only, might be a mix of both. We really ask for your flexibility because the volume of applicants can really ebb and flow depending on where you are, who's organized the workshop, and what community it's targeted for. You should probably plan to stay until about 5 p.m. or whenever the workshop organizer has told you that your role may end. If you plan to leave early, earlier than is advertised, we ask you to let your site coordinator know so that they can plan around that. So typically, there are 6 basic stations at a citizenship workshop. This is the usual configuration. However, be aware that your site organizers might do things a little bit differently the day of. Some groups, for example, might have the applicants staying put and volunteers move around instead of the other way around. However the event is arranged, though, these are the activities that are going to take place no matter what at a citizenship workshop. So these functions will be fulfilled pretty much every time. Someone will visit the intake station to check in. They will be screened and evaluated for eligibility by an attorney or a DOJ accredited rep. Then they will get assistance from a trained volunteer to fill out the 20-page N-400 application. That's where you come in. And then another attorney or DOJ rep will review your work, review the application, make sure that the person has no issues and can safely apply on their own for citizenship. Then they'll get a full copy made of their application and will be sent on their way. In between each station, if this is the configuration, there are usually folks called room captains. They may go by another name, but those folks will be in charge of making sure that each person has everything that they need before they move on to the next station, and that we keep track of where everybody is in the process. We're going to go through the stations very quickly so you can get an idea of what the flow is going to look like at your citizenship event. So at the intake desk, this is the first stop that the applicant will make when they arrive. They'll be greeted, say, hi, are you here to apply for citizenship? And then we'll ask, have you been a green card holder for at least the last 5 years, or 3 if married to a US citizen? Our first job is to make sure that someone is basically eligible to apply for citizenship. To do so, you must have had your for a certain length of time. Then they will give the person a blue intake form, it's usually blue, to start filling out. There will be part of the intake form that only attorneys should fill out, and so the intake folks will indicate that to participants. The next stop that the person is going to make once they've filled out their intake form is they're going to sit down for often a lengthy conversation with an immigration attorney or a Department of Justice accredited rep. And the legal volunteer's job is really to figure out 2 things. Number 1, are they actually eligible to apply for citizenship? There's a number of requirements that they have to meet. And number 2, is their case simple enough for the workshop? The way that our workshops work and the way that actually makes them efficient is that we help folks who can apply for citizenship pro se, meaning they don't need legal representation at their interview because their case is simple enough and approvable, they meet all of the requirements, that we can simply help them prepare the paperwork, and then they can attend the interview and do the citizenship test on their own with flying colors. So if the answer to both of those questions is yes, then the applicant will move on to the next stage, which is the form completion stage. Here's a sample of what our screening form may look like. The one you use the day of may look a little bit different, but when the attorney screens each applicant, they will ask a long series of eligibility questions and note their answers in order to make sure that this person is eligible and doesn't have any potential red flags that may cause them problems with immigration by applying. The attorney or DOJ rep will also review and sign the limited legal advice agreement with the applicant. And then if the applicant ends up not being eligible for citizenship, or if it seems risky for them to apply without attorney representation, we will refer them out. There is a network of both private immigration attorneys as well as low-cost nonprofit organizations that can provide more comprehensive citizenship services for someone whose case is too complicated or perhaps too risky to apply on their own. We still know that that's a success. Just because someone can't proceed on their own with their application at our workshops doesn't mean they can't apply for citizenship ever. And this information is still really valuable for them because then they can take the next step. Station 3 is the forms completion station, and this is where you come in. So the first thing that you'll do is you'll review the applicant's intake form. Half of it will be filled out by them, and then you'll also see all of the attorney's notes from the screening. The attorney may have flagged some things for you, and you'll be able to see kind of what you're dealing with by reviewing that form. And then you're going to fill out the full N-400 application, which is the U.S. citizenship application. You may be using a computer to do that, or you might be doing it on paper, depending on the site. When you're done, the applicant will see another attorney who's going to review your work. They'll review the N-400 form. They may also review what's called an I-912, which is a fee waiver. Not all applicants will have a fee waiver, but some folks who are low income will. And the attorney will spot check and see if there's anything that could have been missed. And they'll do a double check of the person's legal eligibility to make sure that they qualify. If they clear them, then the applicant will move on to the copy station. We make a full copy of their N-400, all of their supporting documentation, and then we'll package their application in a certified mailing envelope. And all that's left for them to do when they leave the workshop is take it to the post office. Finally, we usually have an exit station where we take applicants' photos, we give them a survey so they can tell us how we did, and then we've got lots of civic study materials so that they can go home and study for the naturalization test before they're called for their interview. So what's the deal about citizenship anyway? Why does it matter? When someone has a green card, they are eligible, or they can live here permanently, and they can renew it indefinitely. So why apply for citizenship? There's a number of benefits that are only for US citizens. So the first thing is, of course, freedom from deportation. Once someone naturalizes and becomes a US citizen, they don't have to worry about their green card getting taken away or potentially being deported. They can also travel on a US passport for as long as they want. Currently, green card holders are not supposed to travel outside the US for more than 6 months at a time. Once you have a US passport, however, you can come and go as you please. US citizens can also petition faster for certain family members so that they can get green cards and immigrate to the United States. Only US citizens are eligible for federal jobs, and there are certain public benefits and scholarships that are only available for citizens also. One big reason a lot of people apply for citizenship is because they don't have to spend money renewing their green card every 5 years. Finally, one of the biggest benefits, of course, is being able to vote and being able to run for public office. This is one of the chief reasons that we see in people's exit surveys for why they finally decided to take this step. Another huge benefit for applying for citizenship is that if the applicant has any children who are under 18 and also meet these conditions, they have children who are living with them who are also legal permanent residents, those children automatically become citizens when at least one parent naturalizes. And so a lot of times we see folks at citizenship clinics who have teenage children who are kind of getting close to being 18. And so the parents really want to get their own naturalization so that they can just automatically transmit that freebie citizenship to their children, and their children don't go through this whole process on their own. Now, there are many benefits associated with becoming a US citizen, but there's tons of barriers that keep people from applying. Here in Washington State, the last estimate from a couple of years ago was that there were about 263,000 green card holders in Washington State who might be eligible for citizenship. However, less than 10% have actually applied for citizenship. And some of the reasons for that, first one is cost. There is a steep filing fee. Currently, this video is being recorded in February 2020. Currently, the filing fee is $725, but that is likely to change and go up in the future. Then obtaining legal assistance, a private attorney can be at least $1,000 for a naturalization case, potentially more, and those costs are often too high for people. Sometimes people simply can't find legal help. They may live in an area that doesn't have any practicing immigration attorneys or qualified nonprofit organizations. There is an English language requirement for most applicants, and that can be a barrier as well. And then finally, it can be risky and scary to apply for US citizenship, to come forward and invite the government to investigate your background and your qualifications one more time. All of these barriers are kind of our reason for doing this work. We tend to serve low and middle income applicants who otherwise wouldn't be able to naturalize, usually due to one of these barriers. The next several slides are going to be mostly background for you about the questions that are asked on the citizenship application form. It's not your job to screen and make sure that the person you sit down with meets all of these requirements. That's going to be done by the attorney who screened the applicant that you're working with beforehand. However, it's really helpful background for you to understand exactly why the questions on the N400 are written the way that they are, and will make your experience a little bit more understandable. So sort of the basic naturalization eligibility requirements. Number one, in order to apply for citizenship, you have to be at least 18 years old. You do have to be a green card holder, have to have had your green card for at least 5 years. If you're married to a US citizen, you can fast track it and you can apply after only 3 years of having your green card. There are residency requirements associated with maintaining a primary residence here in the US. There are physical presence requirements, meaning limitations on how much travel you've had outside the US. Most people do have to show that they can speak, read, and write English. They have to prove knowledge of some US history and civics, be willing to swear to the oath of allegiance. And then finally, this is in red because it's a little bit more complicated, is there's a host of laws and regulations about proving that you are someone of good moral character. I want to show you some examples of some permanent resident cards, just so you're familiar with what different ones look like. You don't need to know what all of these mean, but when you sit down with the applicant, they'll probably show you their card. And generally what we're looking for here is their name and their A number. Their A number, it stands for their alien number, and that's kind of their identification number. There's also the date that the card was issued, resident since, and the date that the card was expired. These two in black and white that are in the middle, some of the older ones. The one on top is kind of medium term, and then the one at the bottom that's mostly green is the newest looking one. Okay, so continuous residence. Continuous residence is one of the first, continuous residence is one of the first requirements to apply for citizenship. Like I said, you do have to have had your green card for the last 5 years or 3 years if married to a US citizen and living with them at the time of filing. People are allowed to file 90 days before they hit their 3 or 5 year mark. Again, attorneys are going to be screening for all of this. The residence does need to be continuous, meaning that absences to take trips and things like that are allowed. But extended periods of absence, usually anytime you take a trip more than 6 months long, that may break your residence. And then finally, applicants are required to live for at least 3 months in the state that they are filing in. Physical presence is similar, but a little bit different because this is about actually where you are physically in the world. So it's not where your residence is, where your home is, where your domicile is, but this is actually where you are. So someone has to be physically inside the US for at least half of the previous 5 years, or half of the last 3 years if married to a US citizen. So that means they cannot have spent, if they're filing under the 5-year rule, more than 912 days outside the country. There will be a part on the form where you do have to report someone's full travel history. And this is where that will come in, because you will need to count how many days the person has spent outside the US. Okay, now we're going to get to the good moral character requirement, which is the most complicated area of naturalization law. And the only reason that we're sharing this with you is to let you know how complicated this area of law is. This is why we're so grateful for our attorneys and our DOJ accredited reps for volunteering. Your job as the N400 form filler is not at all to memorize these or apply these. This is only background knowledge for you to be aware of, so you know just how important it is for us to get truthful information from applicants. Your role is really critical in the form filling stage because sometimes people may feel more comfortable with you than they did with the attorney that they saw in the morning, and they may tell you things that they didn't tell the attorney. So don't assume that just because someone was thoroughly screened that they have no issues. There may be things that come out later. Anyway, this is a list of the mandatory bars to good moral character, meaning if someone has any one of these in their background, then they are by law unable to establish good moral character and unable to naturalize. If someone is convicted of what's called an aggravated felony anytime after November 29th, 1990, that date relates to a law change that happened on that date. An aggravated felony is something that is not easily defined at all. And then also, if someone has a conviction or any of the following within the 3 or 5 year period that they're filing under, they also cannot show good moral character. And it's quite a long list, but being convicted of or admitting to what's called a crime involving moral turpitude, committing 2 or more offenses and being sentenced to more than 5 years in jail, any violation associated with drugs, providing false testimony to get an immigration benefit, prostitution, polygamy, helping someone enter the country without documents, that's known in the law as alien smuggling, and several others. There are also some discretionary bars, which mean that if someone has any of this in their background, it doesn't mean that they can't establish good moral character, but the officer can use their discretion to deny their case. So this includes providing incorrect or false information to a government official, not paying child support, registering to vote, voting, claiming to be a US citizen in any way. That's more common than you might expect. Failure to pay taxes, failure to register for the selective service. And then there is sort of a catch-all component here, which says, quote, other criminal violations or unlawful acts. There are also some even more serious things that we want to look out for in the attorney screening, which is that some people, when applying for citizenship, may put themselves at risk of being deported, not simply being denied citizenship, but actually being deported, having their green card taken away. And these are folks who have any of the following in their background: an aggravated felony, a false claim to US citizenship, giving false or misleading information to the government, committing a crime involving moral turpitude within 5 years of getting their green card, voting illegally, obtaining their green card illegally. You might say, hey, didn't I just hear these on the last slide? And yes, some of these are similar, but they're not exactly the same as the bars to good moral character for naturalization. So someone might be eligible to naturalize actually, but also they're deportable and vice versa. The point of all this is not for you to memorize this, but just to know and appreciate that applying for citizenship for certain people may be a big risk, and we take our jobs really seriously at the workshop to give the best possible legal advice through the screening and through the rest of the process. The next requirement to apply for naturalization is showing English language ability and knowledge of US history and civics. Most applicants do have to show that they can speak, read, and write basic English. In the interview, the officer is going to ask the applicant questions about their own application in English. So that's the spoken component. The reading and writing test is pretty simple. The applicant has to write one sentence in English. For the reading, the officer will show them a sentence in English and the applicant has to read it aloud. Generally, what we see is that the speaking test is the most complicated because they're essentially having a high-level conversation about what appears in their immigration application. Finally, there is the famous naturalization test, which you may have heard about. The government provides a list of 100 questions and their answers, and applicants have to study this. And at their interview, the officer is going to give them 10 questions, and they have to answer 6 of those correctly. It's not a written test, it's an oral test, but they don't know which questions they're going to be asked, so they do have to prepare for all of them. There are some exemptions available for certain people to these requirements. So, and it depends on how old the person is and how long they've had their green card, both together. So if someone is at least 50 years old and they've been a green card holder for 20 years when they file, they can do the whole interview and the test in their own language. So they don't have to learn English, but they still do have to learn all of the US history and government information. The same exemption applies to someone who is at least 55 years old and has been a green card holder for at least 15 years. There's another level of exemption for folks who are a little bit older. If you are at least 65 years old and have had your green card for 20 years, both together, you can do the interview in your own language and the civics exam, but you'll only have to study 20 of the simplest questions instead of the full 100. So you study 20, they ask you 10, and you have to get 6 correctly. Many people at citizenship workshops are going to qualify for these exemptions. If they don't qualify for the exemption and they really don't speak enough English in order to proceed to their naturalization interview in English, we will refer them out at the screening station usually to local ESL classes where they can practice and improve. Sometimes people actually do speak well enough English in order to navigate their citizenship interview on their own, but they feel more comfortable using their own language at the workshop, especially in order to understand and really fill out a legal form properly. So we have interpreters available at citizenship workshops, and people can use them even if they don't qualify for one of these exemptions. But we do want to make sure that there's nothing at all lost in translation especially when they're completing the N-400 form. I want to talk quickly about the N-648 disability waiver, which is mentioned at the bottom of the slide. There is a medical exception available for people who cannot memorize information or study for the test or learn English at all because of a medical condition. USCIS will grant an exception from the test completely if someone has a medical condition, for example, like Alzheimer's, a traumatic brain injury, dementia, but these forms have to be filled out by the applicant's doctor. They're quite complicated, and we always recommend that the person get their own individual legal representation because the government can be quite strict when adjudicating these waivers. If your applicant that you're working with indicates that, the test is going to be impossible for me, I could never learn English, I can't memorize anything, please do flag someone down immediately and don't fill out the application form because this is not somebody whose case is going to be simple enough to work on at the workshop. We want to refer them out to another organization who can help them both with the form and go back and forth with their doctor to get their disability waiver completed properly. Now, occasionally this doesn't come out right away. It might not be apparent, but you may find that halfway through the application form, as you're filling it out with the person, you start to realize that the applicant has a really hard time remembering basic information, like where they've lived and when, or where they've worked. use your judgment, and if it seems like there may be some memory issues, you want to also flag down one of your site coordinators, because that may indicate that here's somebody who's eligible for the N648, and we want to refer them out right away. Okay, so when you are getting started filling out the N400 with an applicant, you'll want to start by introducing yourself. So you might say something like, "Hi, I'm Sarah. It's so nice to meet you. I'm not a lawyer, but I've been trained to help you fill out your citizenship application form. I'm going to be asking you all of the questions on the form. If you don't understand something, just ask. I'll be happy to explain it differently. It's really important that you answer all these questions honestly. I've signed a confidentiality agreement today, and I will not share anything you tell me with anybody, except for the attorneys and the staff that are here today to help you." That's a way that you can kind of explain your role to the person and emphasize that the confidentiality of their information is of utmost importance to you. I recommend that you sit next to the applicant, not across a table from your applicant, because that way they can check your work. You may spell something wrong, you may type a number wrong, mix up a date. It's helpful to have them edit as you go, and that way you don't accidentally introduce kind of a careless error into their application form. Finally, I will say if you think that your applicant could benefit from some type of special accommodation, also let a site coordinator know. So for example, if they seem really nervous or agitated, we might be able to set you up in a more quiet or private space so that you can do the form completion. Or if they have a health condition and you think it would behoove us to try to fast track them through the process if possible, let us know. We want to keep the experience of the applicants at #1 priority. The last thing is that we recommend that you work with the applicant alone. We don't want other family members to be seated with you. It's really important, especially because the types of questions you might be asking them can be pretty sensitive, that they don't feel pressure to answer a certain way because their spouse or family member is sitting next to them. Also, because of the space required, sometimes we just don't have room for family members anyway. The site coordinators will enforce this, but just in case you happen to have someone sit down and they have someone else with you, let a site coordinator know. You always have to use a black pen to complete the form or a computer. Make sure that you ask all questions on the form. Don't make assumptions or answer for the person. If you're not sure how to fill something out, or if they provide an answer that kind of tingles your spidey sense, maybe it brings up a red flag that the attorney didn't catch, there's something there that you're not sure about, you've got sticky notes at your desk that you should put on the application form and write a note to the attorney to say, "Hey, check this out." If the applicant needs a fee waiver, every workshop will handle this a little bit differently. If you've been trained to complete fee waivers, you might just do one for the person that you're working with if they qualify. Otherwise, there will be volunteers who can do that. So you'll want to tell your site coordinator. If you're using an interpreter, I recommend that the interpreter sit across from you and you sit next to the applicant because you really should be looking at the applicant when they're speaking. The interpreter is a mouthpiece only. They're not the applicant. So don't have any side conversations with the interpreter. We don't want interpreters to paraphrase what the person has said. It really should be as close to word-for-word translation as possible. And remember, your relationship is with the applicant, not the interpreter. There are translated N400s available in many, many languages that should be available on site. So make sure to use them. Unless no translation exists, the interpreter should not just be translating all these questions from their head. We've got translated N400s available in Spanish, Chinese, Korean, Arabic, Vietnamese, and a few other languages. So they should really be using those translations to make sure that we're consistent with the meaning of the questions. The interpreter also is going to need to sign the intake form and sign the N400. We're going to talk a little bit more about that later. If you're using a computer to fill out the N400, make sure that you use Adobe Reader, not a browser, not Dropbox. Sometimes using Dropbox or a browser will let you edit the form, but importantly, it will not let you save the form and you will lose all of your work. So make sure that you've got the form open in Adobe Acrobat or Adobe Reader. We recommend that you save often and save in the format with the client's name. After you've done maybe a page, you should save it, close it, reopen, just to make sure that your work is saving. There's nothing worse than getting to the end of the form and trying to save and realizing that nothing is working. The instructions for how you will save and print and everything will vary depending on your site, but usually we save the completed application either to a flash drive or to something like Dropbox in order to have it accessible for the attorney. When you're totally done with the application, like I said, you want to add sticky notes to the areas that you have questions for the attorney about, want them to look at something closer, or if there's missing information. You'll raise your hand and let the person in charge of your area know that the applicant is ready to get reviewed by the attorney at quality review. And typically we will send the client on with a hard copy application, so you'll print it, and a USB drive with their application on it. This is, of course, if it was completed on a computer. And that way the quality review attorney can look through the printed app and they can make edits to the electronic version with the USB. Finally, we really want to make sure that you complete the intake checklist. This is what that might look like. There's a section on the individual client's intake form for each volunteer to document what they did. So you want to make sure that you check off that you completed the N400 with the person. If you use an interpreter, that they sign the interpreter's statement, noted any missing information or red flags for attorney. And there's a few other things that will go into more detail the morning of your event. But most important thing is that you check off what you did and that you print your name and signature. The attorney that reviews the application may have some questions for you later, and it'll be hard to know who completed this person's form unless you wrote it down right here. Make sure that you do that. The room captain should enforce this too if you forget. The next slides are going to go over the entire N400 form, and we're just going to point out specific sections that you should pay special attention to. So this is page 1, part 1. This part will address the continuous residence requirement. So at a citizenship workshop, you're mostly going to see checking box 1A. I've been a permanent resident of the US for at least 5 years. Sometimes the applicant is eligible under both A and B. They've been a resident for 5 years, and they've also been married to a US citizen for at least 3 years. But if they qualify for both, sometimes we see people who qualify based on both the 5-year rule and the 3-year rule because they are married to US citizens. However, in that case, it's usually preferable to select option A. I've been an LPR for 5 years, period. When we check B, it requires us to submit additional evidence about the person's marriage, including proof that their marriage is legit and not fraudulent. So unless someone has had their green card for like less than 5 years and their only option is to apply under B, that's usually the only time we're going to do that. So select A unless instructed otherwise, or if the person doesn't qualify based on 5 years. You're going to fill in the applicant's current legal name. This is their actual legal name, and then down here is your name as it appears on the permanent resident card exactly. And these may not be the same thing. Sometimes permanent resident cards can write their names wrong, or especially folks with 2 last names, they will omit one of them. We want to make sure that we write it exactly how it appears on the permanent resident card there and the legal name above. Part 2 is more information about the applicant. We do have to indicate any other names the person's used, maiden names, nicknames, whatever the case may be. Question 4, they ask if the person would like to legally change their name. I don't really know why they ask this on this form, because you can only change your name at judicial oath ceremonies, of which none are really conducted in Washington. So someone may want to change their name, but checking this box does not actually give them that power. They have to do a court order before they go to their interview, and then bring that court order with them. Anyway, if anyone answers yes to this question, feel free to flag down a site coordinator and we can explain this to the applicant. But generally, there is no way to legally change your name simply by indicating on this form. Question 9, the date that you became a legal permanent resident. This is the date that appears on the green card. So you want to confirm the eligibility based on what you selected in part 1, whether it's 3 or 5 years with the date here. Next, the form asks whether the person qualifies for any of the exemptions. So if someone qualifies for the English language exemption based on their age and how many years they've had their green card, you'll select that. And again, this question, number 12, do you have a physical or developmental disability or impairment that prevents you from demonstrating your knowledge of the English language and civics? Remember, selecting yes means that the person wants a disability waiver, CN 648. We do not do these at workshops. So if someone indicates they want to answer yes to that question, we need to refer them out because those cases are quite complicated and they need more specialized assistance. However, the disability waiver question here, number 12, is different from the accommodations section in part 3. These are accommodations that the person may request at their interview due to some sort of disability. These are totally different. They do not exempt the person from the test or the language requirement, but it's simply a request for reasonable accommodations at the interview. So for example, you could say, my eyesight isn't so good, I need large print forms available at my interview, or I'm hard of hearing, I need the officer to speak loudly and repeat themselves as necessary. I need to go to a wheelchair accessible location. Most USCIS offices are accessible, but any accommodations that the person may request, if let's say they have a service animal, a seeing eye dog, for example, they can request that here. But again, these don't exempt the applicant from any of the tests. It's just a reasonable accommodation. Number 4, part 4, contact information. Pretty self-explanatory. It continues down through part 5. So the residence here is their current physical address. So where do they actually live right now? Part B is the current mailing address. Now, most people, their physical address is the same as their mailing address, but always ask, don't assume. Ask them if they get mail somewhere besides their home. Some people have PO boxes, for example. USCIS will only send them their appointment notices via postal mail. So if they can't get mail at the address that they've listed, then they will not get any notices and they will miss their appointments. So this section is really important. Part 5 continues on the next page, and this is where the person has to list all the addresses that they've lived at for the past 5 years. You start with the most recent, and then you work backward until you hit 5 years. The applicant's intake form does have a chart where we've asked them to prepare in advance a list of all the addresses that they've lived at. I would start there and see how many addresses you're talking about. Sometimes, you know, someone has lived at the same house for 20 years, and then in that case, your job is really easy. If someone has lived at more than maybe 3 addresses in the last 5 years, probably a good idea to list them out on scratch paper first and make sure that they're correct, that there are no gaps, and then transfer to the N400. Sometimes people will list the addresses where they've, you know, signed a lease or had a mortgage, but they don't actually account for 3 months here or there that they were staying with family, for example. The entire 5-year period has to be covered with no gaps. One important thing to note, if someone took a trip, let's say, to their home country for 2 months or whatever, that's not a residence. The residence is where they live and where they keep all of their stuff, like where they get mail and where their bank statements go and all of that. So we don't list trips here, that's gonna come later. But we are gonna list all of their residences, and there cannot be any gaps. Sometimes people, especially if they've lived multiple places, they don't remember exactly. So you might ask questions to jog their memory. You can say, you know, do you remember moving in the winter? Do you remember signing another lease, or was it just a 1-year lease? You can encourage them to call or text their family and friends to see if they can figure out when they lived where. If the applicant doesn't know full or exact dates, that's totally fine. You just want to get as close as possible without putting down something that's inaccurate. So let's say they don't remember the date they moved from place to place. You can use the month only. You could say March 2018, for example, or if you can't narrow it down that far, you could say spring 2018. You'll see that this form only provides space for 5 addresses. So if someone has lived at more than 5 addresses, you have to add additional sheets, and we actually have pre-made addendums there that are ready for you to use. They're exactly like this format, and you'll add the additional addresses there. Part 6, information about your parents. So this section is where USCIS is actually trying to figure out whether the applicant might already be a US citizen. If anyone has just one US citizen parent, and it appears that their parent became a citizen like any time before the applicant turned 18, your applicant might be a US citizen and just not know it yet. It sounds crazy, but it's a lot more common than you think. So if this is the case for your applicant, you want to stop and grab a site coordinator. It should have been caught at screening, but you never know. And you don't want to complete the whole form when it might not be necessary. You'll see at the top, the first question is were your parents married before your 18th birthday? And the second question is your mother a US citizen? If you answer yes, you fill out this whole section, but if you answer no, then you move on. So pay attention to that, because sometimes you can get tripped up in filling out this section when you don't need to. Same question, is your father a US citizen, yes or no? If you answer no, then you move on and you don't complete that section. Part 7 is biographic information. This is information for USCIS to run the background check. They will have the applicant's fingerprints, and then they'll also run these indicators. You can copy some of this information from the applicant's driver's license if they have one. The ethnicity and race options do leave something to be desired. So have the applicant do their best in, identifying what best describes them. There are, however, plenty of options for eye color and hair color. Part 8. This is similar to the residence history, except this time we're going to list anywhere we've worked or attended school for the past 5 years. We start with the most recent, and then we go all the way back until we hit 5 years. We can't have any gaps, and we have to include periods of unemployment as separate entries. So the philosophy here is similar to the addresses. If someone has had more than like 2 or 3 jobs, I'd really recommend listing them on scratch paper first to get the dates right, the order right, make sure you don't have any gaps, and then transfer them over to the form. Sometimes a rookie mistake is you just start copying stuff into the form, and then you're done and you realize there's a 6-month gap after the first one, and you have to erase all of your work and re-enter everything. This section also only has 4 entries, and so we have pre-made addendums that look just like this page that you can fill out any additional schools or employment during the last 5 years. It's probably a good idea at this point to cross-check the employment section with your residence section, especially for people who have had multiple jobs and lived at multiple places, because you want to make sure that the dates align. You don't want to have someone who looks like they're working somewhere in Kent at the same time they said they were living in California. Sometimes people's memories is not perfect, and if there's any discrepancies, you can try to rectify those before moving on. Part 9 is where we are going to document all trips that the person has taken outside the U.S. during the last 5 years. You'll see that the requirement is the trip has to be 24 hours or longer. So if they went to Canada for 3 hours and they came back, that doesn't count as a full day. We're going to list all of our trips in the chart here, starting with the most recent one and working backwards. We'll have to do the date the person left the U.S., the date they returned to the U.S., did the trip last 6 months or more, the countries where the person went to, and then how many days they spent outside the U.S. If someone has a trip that lasted longer than 6 months, a single trip, that is a red flag, and you'll want to flag it for the attorney. That could be an indicator to USCIS that the person abandoned their residence and perhaps did not maintain continuous residence here in the US, because 6 months and longer can indicate that they were living in another country, potentially working in another country. And the terms of your permanent residency in the US is that you can't go live and work elsewhere, or you are giving up your residency. We're counting up the total days outside the United States, and we're going to put that total once we get it here in number 1. We have to count how many days we spent outside the US and how many total trips. Remember the physical presence rule. You have to have spent more than half of the last 5 years here in the US. So if the total number of days for the 5-year rule is close to 913, that's another red flag for the attorney. Most of the time you will not get nearly that many days, but 913 is kind of the magic number for the 5-year rule. Or if someone is applying under the 3-year fast track marriage rule, half of 3 years is 547 days. It's super common for some applicants to not remember all of their trips. If they can't remember exact dates, you can kind of start trying to estimate the trips that they've taken by asking probing questions. So what time of year was it? Were you going there to celebrate some sort of special occasion? Like, was it for Christmas holidays or somebody's birthday? Do you or anyone in your family have e-tickets maybe on your phone or in your email that you can look up? If they can't remember the exact dates, they can also use months. It's totally fine to estimate if you say, you know, March 2016 through May 2016, took a trip to wherever. But do try to get as close as possible. And I have a few more tricks to share with you after that. There is a travel addendum that's available on site, but it should only be used for specific circumstances. Usually when someone engages in a lot of very repetitive travel to the same place. So for example, let's say somebody goes to Canada 3 days a month for work, and they've been doing that for the last 5 years. It's going to be really hard for them to list all of those travel dates, and it's going to be super long that's a good case in which you could use the pre-prepared travel addendum. And the addendum says, I cannot remember the exact dates of all my trips taken outside the US, but I do know I only traveled to Canada for no more than 5 days at a time. And I know that I was only outside the US for about 100 days total in the last 5 years. We do have a pre-printed statement that's just like that you can fill in. But again, that's a last resort, and it's best suited for specific situations in which someone has a lot of very repetitive travel. A few tips that may help you, especially if you are using a computer at the event, but you can also look this up on your phone. The Customs and Border Protection maintains a website that tracks entries and exits by passport number for the last 5 years. It's only air travel, so if someone is driving to and from Mexico or Canada, for example, that's not going to show up here. But if someone is flying, this can be pretty good. If they have their passport, you can enter their passport information to pull up a list of their travel dates. Remember that this history is tied to the passport number. So if someone used a different passport a few years ago and then they renewed it and they got a new one, you have to run a search for both numbers in order to get the full travel history. The codes that are listed in the location are not airport codes, they're CBP port of entry codes. Just something to be aware of. But it should show you the departure date, departure from the US, and then arrival in the US, which should be the ends of each trip. Now, you will see occasionally that the travel history is not complete for some reason. They missed a scan in or out. And you'll see that because if someone has, 5 trips, they should have been scanned 10 times, an entry and an exit per trip. But you might see that they only have 9. So you'll have to do a little bit of detective work to make sure that the way you've got the dates lined up is accurate. There's a great website that you can also use to calculate the length of a trip, and it's called timeanddate.com. And this is where you can enter the start date of the trip, the end date of the trip, and it'll auto-calculate how many days each trip was. This can be a real time saver if you've got someone with lots of travel. Part 10 of the form is marital history. USCIS asks lots of nosy questions about the person's spouse, their ex-spouse, their spouse's ex-spouse, because they're trying to figure out if there's any marriage fraud in order to obtain a green card. All of this section is pretty self-explanatory. Question 6, if this person doesn't know, exactly when their spouse became a U.S. citizen, that's quite common. You can just flag that, and the person can write it in later. That's no problem. Question 7, if the spouse is not a U.S. citizen, and they're also not an LPR, for example, let's say they don't have legal status, they're undocumented. You might say none or pending, maybe they have a pending petition, ask the person, but we don't want to write undocumented or anything like that. Question 8, how many times has your current spouse been married? So if the person's spouse has been married in the past, you have to put their information here too. So the person probably doesn't have that offhand. They may have to call their husband or wife to figure that information out. If you find that someone has multiple short marriages in a short period of time, that can be a red flag for the attorney. They could have an issue there. Often this section has some missing information because people don't know the date of birth, for example, of their ex-husband's ex-wife. That's okay. We'll put a sticky note there, and typically it's something that the person can fill in later on their own. If someone has more previous marriages than will fit on this form, we have supplemental sheets that you can use for that. That'll be in this format. The next section is about the person's children. All children have to be listed on the form. It doesn't matter whether they're minors, whether they're adults, whether they are living in the US or living in another country. It doesn't matter what immigration status they have. It also includes deceased children. So if the person had a child who maybe is no longer alive, all children have to be listed. There is only space for 4 on this form. So we have an addendum that you can use that looks just like this page to add additional children. If you have someone who is expecting a child, but the child isn't born yet, that child does not have to be listed. They can simply bring the child's birth certificate to their interview, and USCIS will update their application then. Often people forget this little box where you indicate the total number of children. It's easy to overlook, but there it is. Part 12, this is where we get into the questions about good moral character, as well as possible deportability issues. So when we get to this section, you'll want to pause and make sure to ask these questions slowly and use different phrasing in order to make sure that the applicant understands what you're asking. It may help to introduce this section just to break the tension a little bit, and you can say something like, you know, the government has decided that everyone who becomes a citizen has to answer these questions. Some of them might be awkward or they may not apply to you, but I can't make any assumptions or answer for you. I have to ask you all of them. So the first series of questions is where we are trying to figure out if the person may have falsely claimed that they were a US citizen, which is really important because this can be a deportation issue. So if you have any yes answers here, you always want to flag that for the attorney with a sticky note so they can dig deeper. Questions 1 through 3 are about registering to vote or voting. Here in Washington, since we have vote by mail, and since there is voter registration at Department of Licensing, sometimes people do register to vote on accident and they don't mean to. So we want to ask, you know, have you ever gotten a ballot in the mail that had your name on it? Have you ever filled out a ballot to vote? You can actually check to see if someone might be registered to vote by going to voter.votewa.gov. And that will tell you, you can look up their voter registration by name and by driver's license number in order to see if they're registered to vote. If someone has any doubt about whether they might be registered, always a good idea to make a quick check. Question 4 is if someone has ever had a hereditary title or order of nobility in any foreign country. So we haven't gotten one of those yet, but if you do, they do have to give up their title. Part 12, more good moral character stuff. The first few questions are about whether they've owed taxes. This does not mean like if they haven't yet filed their taxes for this year. It means overdue, like past due taxes. So if they've gotten a notice from the IRS saying you owe taxes, that's what that means. 7, have you ever not filed a federal, state, or local tax return since you became a lawful permanent resident? Many people have incomes that are low enough that mean that they're not legally required to file a tax return. So if that's the case, they should check, yes, I have not filed my taxes, but we do have a pre-made statement that says I did not file my taxes in this and this year or years because my income was below the legal filing threshold. If that's true for your client, you can use that form to show that, but you will want to check yes on 7A and submit that explanation. 7B, did you consider yourself to be a non-US resident? This is the government trying to figure out if the applicant abandoned their residence here in the US by maybe filing taxes and saying that they weren't actually a resident. That's a big red flag if the person says yes to that, but it tends to be pretty uncommon. Question 9, the person has to list membership in any organizations or groups. Of course, the government is looking for things like terrorism, violence, overthrowing a government, things like that. But it's also an opportunity to show membership in positive groups that can show good moral character. It's not a throwaway question just for bad stuff. So ask them if they're a member of a volunteer group, a club, a sports team, a church, maybe their child's school, PTA, whatever the case may be. But this is an opportunity to show positive engagement with the community. Question 10, have you ever been a member of any of the following? Folks from certain countries, including China, may have been obligated to join the Communist Party. If that's true, we have a supplementary addendum that says, I was a member of the Communist Party, but it was required in my home country. Any yes answer in this section is definitely a flag for the attorney to review. Question 13, did the person have any involvement with the Nazi government of Germany? Hopefully the answer to that question is no. Okay, these are a series of questions about involvement in one way or another with genocide or military action. Questions 14, 15, and 16. These are worded quite broadly. Were you ever involved in any way with any of the following? Genocide, torture, killing, hurting somebody, lots of other things. Generally, the current legal guidance is that if someone was a victim of genocide or torture or any of these things, that they do not have to answer yes. However, if they were involved in perpetrating any of these things, even if it was under duress, they do need to answer yes, and that would be something that the attorney would need to look at very seriously. Keep an eye, 17 and 18. If the answer to these questions are no, you don't have to answer the ones below, so just pay attention to the form. I really recommend in this section that you try to explain the terms if you need to. If you see that someone is a little bit confused or they don't understand what you're saying, you want to make sure that they understand what they're answering and that they're not just reflexively saying no, 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 because they know that all of this is bad stuff. So one thing that's common that happens in naturalization interviews is the officer will ask someone, have you ever been involved in genocide? The person says no, and then the officer says, what's genocide? You don't want to put someone in that situation, so your time with them here is an opportunity to explain some of those terms. And you can ask them, do you understand what that means? And then if they say no, you can explain. It's a little bit more difficult as you try to explain the difference between paramilitary, self-defense unit, vigilante group, rebel group, guerrilla group, militia, etc. But you can get a feel for whether they've been involved in anything akin to that by having a conversation with them about it. Any yes answer to this section is a flag for attorneys to review as well. Questions 22 through 29 deal with arrests and convictions of crimes. This is another place where it's very helpful to rephrase questions to make sure that people understand. For example, question 23, have you ever been arrested, cited, or detained by a law enforcement officer, including any immigration official, for any reason? This actually does include speeding tickets. It does not include parking tickets or tickets issued by red light cameras. They have to be issued by an officer, but we want to ask the person, have you ever been in handcuffs? Have you ever been inside a police car? Things like that. Question 24, have you ever been charged with committing, attempting to commit, or assisting in a crime or offense? So we can say, have you ever seen a judge or been to court? Have you ever had a lawyer for something to go to court? Often in the criminal justice system, someone is able to pay a fine, complete probation, or plead to something and then after a period of good behavior, they're told by the judge and or their lawyer that their record is clean and that they have nothing in their record and everything is taken care of. That may be true for criminal purposes. Let's say they got a DUI, completed the terms of their probation, and after a period of time it was wiped from their record. If they were pulled over for a second DUI, perhaps for the criminal purposes, they only have one DUI. The other one, quote unquote, doesn't exist. But in the immigration context, arrests and convictions truly do live forever. And so it's really important that you ask gently but consistently here, because someone may tell you no because, a long time ago a judge or a lawyer said, you're clean, everything's gone from your record. They may think that they can say no to these questions. But for immigration purposes, a conviction unfortunately does live forever. So when you get to the, especially these questions about 25, 26, been convicted of a crime or offense, you can say, have you ever been convicted even if a judge or a lawyer said your charges were dropped? Has someone ever told you that your record was clean or that your record was wiped? 26 can be hard for people to understand, and it's a mouthful. Have you ever been placed in alternative sentencing or a rehabilitative program? For example, diversion, deferred prosecution, withheld adjudication, deferred adjudication. Another way of phrasing that might be, have you ever been offered a different penalty instead of jail time? Like, for example, did someone say you can go to rehab or go to counseling or do community service or pay a fine instead of going to jail? Okay. It's really important, again, that you be thorough in this section, because criminal issues are one of the chief kind of good moral character bars. This next section in question 29, there's a chart that you have to fill out if the person has been arrested or cited or convicted of any crimes. So here's a typical sample of what we might see at a citizenship workshop. Someone had a speeding ticket. We put the date, the location, and the outcome. In this case, someone also had a DUI. Sometimes if the person has been convicted of a crime, but they are actually okay to file their application, the attorney will have completed this for you, but sometimes not. If you're not sure how to document this section, feel free to add a sticky note for the attorney and have them fill it in. But remember, we do need to include traffic citations here. If we don't know the exact date, that's okay, but we want to get as close as possible. It's important to be thorough in this section as well, because USCIS will do a fingerprint nationwide background check on every applicant. So even if it's something as minor as speeding or a DUI, let's say in this case, it will show up on their background check, and so it's not in the applicant's best interest to leave anything off of the N-400 form. Part 12, Good Moral Character, continues. These are some of the more awkward questions on the form, where you will be asking someone if they are a habitual alcoholic, sold or smuggled drugs, been a prostitute, things like that. So you may want to give your disclaimer again to the person that you have to ask them all of these questions, and you are not there to make any assumptions about them, and you've heard it all, and nothing is going to surprise you or offend you in any way. Questions 31 through 36 concern previous actions with the immigration system. So any yes answer is going to be a flag for the attorney. And remember, these questions apply not just since the person got their green card, but ever. That's why the form puts them in all caps, ever, ever, ever. So even if it was 30 years ago, even if it was way before they got their green card, have you ever given any U.S. government official any information or documentation that was fake, false, misleading? This is important, especially for folks who have maybe crossed the border at some point in the distant past, or been arrested by ICE or immigration at some point. If someone's ever been deported, placed in removal proceedings, again, whether it was before or after they got their green card, super important. The last section is about their military history, if they've ever been a member of the U.S. military, disciplined by the military, or court-martialed. That tends to be rare, but you have to ask the question anyway. When we talk about selective service, this is the draft. We have not had an active draft in this country for some time, but it is still required for all men between the ages of 18 and 26 to register for the selective service. A lot of men aren't aware of this, especially folks who are immigrants, but it is a requirement. So if they lived in the U.S. anytime between the ages of 18 and 26, they had to have registered. The only exception is if they were in non-immigrant status. So let's say they were here on a student visa, a work visa, they were here as a tourist, they don't need to have registered. But even if they were here without status, if they were undocumented, they still needed to have registered. Sometimes it's very rare that people will remember having registered for the selective service, but you can check. You can go to sss.gov and enter the person's name and social security number, and you can see if they were registered. Sometimes results don't come back. That's pretty normal. And there's different ways that you should treat this depending on how old your client is. Remember, this only applies to male clients. If you're working with a female client, you can skip all of this. If someone you're working with is under 26 and it appears that they're unregistered in the system, you can register them for the selective service right there at the event. Print their print their selective service registration confirmation, and then you're done. If the applicant is already over the age of 31, then and they did not register for the selective service, then there's a little addendum that we have the person sign that they submit with their application, where they indicate that they didn't know it was a requirement to register, and if they had known, they would have done it. It's kind of like a little apology, and that's all they need if they're over 31. If they're between the ages of 27 and 31, there's an extra step that you have to take, and I'll explain why. So we talked about the window that people are applying in is the 5-year window, right? And so what happens in the last 5 years is usually more important for good moral character purposes than what happened more than 5 years ago. So if I'm a man who is over 31, the last time I could have possibly registered for the selective service at age 26 was more than 5 years ago. So my failure to register is less of a big deal. However, let's say I'm 28 years old. I should have registered at least 2 years ago. So my failure to register is taken a little bit more seriously by USCIS. In that case, what I need to do is I need to sign the quote-unquote apology addendum, same as the one for men over 31. And then I have to do one more thing, which is I need to request a status info letter from the selective service, which is basically a statement from the selective service about that you should have registered or what kind of status you were in while you were here. It's not particularly helpful, but it is something that's required. It's not terribly difficult to get. There is a request letter form that we will have on site. The applicant simply has to fill it out. They'll mail it to selective service basically at the same time they mail their citizenship application, and then they'll get the info letter back within about 6 or 8 weeks, and that's what they need to bring to their interview. You may not remember this the day of, and it may be that you never get any male applicants who are between the ages of 27 and 31 were required to register and didn't. But if you find yourself in that situation the day of your clinic, just remember that there's something that you have to do And you can flag whoever's in charge of your station for a reminder of these rules. Here's what that selective service addendum looks like. It's pretty basic, and it says that I was present in the US between my 18th and 26th birthdays, and I did not register. But I didn't do it on purpose. I want to go back really quickly and take a look at item 45 through 50. These are actually the individual parts of the oath of allegiance. So the person should answer yes to all of these questions because it is a requirement to take the oath of citizenship in order to apply. There is a modified version of the oath available for people whose religious practices or deeply held beliefs prevent them from swearing anything or bearing arms. And so you can waive question 48 and 47 and 48, basically to not swear to anything and then to not bear arms. You should flag this section for the attorney with sticky notes. This is not an automatic waiver. The applicant will have to write a statement about their beliefs. They may want to provide some religious evidence from whatever faith institution they belong to, and they have to discuss their opposition at the interview. USCIS does not have to grant the oath waivers. So this really is for someone who has a sincerely held objection to these items. This isn't for someone who kind of casually doesn't want to bear arms. You should remind your applicants that we have not had an active draft in this country in a very long time. And so this does not mean that they're going to be called up at any moment to bear arms. It is just a necessary part of the oath. And the waivers available really are reserved for people with religious and deeply held objections. Once you get to this part, you are basically almost done with your portion of the form. There is an applicant's statement and certification where the applicant will check that either I understand English and I understood every question, or an interpreter translated every question on the form to me. They'll check one or the other. If they use an interpreter, they'll fill in the language. And then typically at a workshop, the organization sponsoring the workshop is a preparer, but you're going to be given instructions at your site for how to complete this. You do not want to have the applicant sign at the workshop. Usually the applicant is not going to sign until they make it all the way through to quality review, and the attorney has reviewed the whole form and cleared it, and then they can sign it. So we'll skip this section. The interpreter section, if you used an interpreter, they need to fill out this section with their name, and then typically it's the sponsoring organization's address that you will put here, but wait for instructions from your site about this. If you were the interpreter, let's say you speak Spanish and you're speaking Spanish with the applicant and then translating their answers into the form, you are going to be the interpreter. So in that case, you want to submit your own information here. You'll put your own name and then the sponsoring organization typically as the interpreter. Don't forget to sign. The signature is often forgotten, and it's super important because sometimes when the application goes to quality review, we notice the signature is missing and then we can't find the person. Like I said, in workshops, usually the preparer is the organizational sponsor, but don't worry too much about this page. Your site lead is going to give you instructions on how to fill this part out. Same thing here. No matter what, once you get to part 16, we're going to stop and we're not going to touch anything after part 16. This is for the interview only. Okay. There are many addendas that I mentioned earlier that are going to be available on site. If you don't have enough room for certain things on the form, or you have to give additional explanation. There are two types of addenda. So for stuff that you just don't have enough room for, we've got pre-made addenda for children, trips, jobs, and addresses that don't fit on the form. The other category of addenda is, I have to explain to the government why blah, blah, blah. So we've got pre-made addendums to explain why I didn't register for the Selective Service, why I didn't file taxes, why I joined the Communist Party, and there's a blank one to explain anything else you want to explain. These are all pre-made and they're available at your station, and you can use them however you need. I want to mention briefly about fee waivers. You may be asked to do very preliminary screening for fee waiver eligibility once you're done with the N400. There's an easy screening form at your table that you can use to figure out if the person is eligible. There is a separate training on how to actually complete these applications, and so you'll want to make sure that you do that before you fill out any fee waivers. Currently, as of the date that this video is being recorded in February 2020, there are a few different fee waivers available. There's a full fee waiver, meaning the person pays $0 to apply for citizenship. That's available if the person gets means-tested benefits, so something based in being low income. Food stamps, for example, Medicaid, those are the most common ones. Or their household income is less than 150% of the poverty line based on their income from their taxes. That's for a full, complete fee waiver. There is also a reduced fee available for naturalization for people whose income is between 150% and 200% of the poverty line based on their income. There has been some litigation and some actions by the government that might put fee waivers and reduced fee requests in jeopardy, but as of February 2020, those are still available. Like I said, there is a separate training on these in order to complete them. But we want you to be familiar with the fact that fee waivers exist, and then you can at least screen people to see if they might be qualified. Then they would go to another volunteer who knows how to complete these applications to actually do them. We really ask you at these events to be flexible. Every event is totally different. It depends on who's organizing it, the venue, how many people are there. They're all designed a little bit differently, and we really need your flexibility about your role and your duties. You know, the timing when you'll receive your first applicant may change. The timing of when you will get your lunch break may change. So please be flexible and patient. Your clients will be assigned to you as they're finished screening, which may take a different amount of time depending on the person. Technical issues can happen. We may need to fill out forms by hand if the printer breaks down, or maybe you're the only person on site who speaks a specific language and we have to ask you to interpret instead of filling out forms. So just know that anytime your site coordinators make adjustments, it's because we're trying to make the experience for the applicants as seamless as humanly possible. Okay, I want to talk through something really important at these workshops, which is that you're going to be serving many people who might have different experiences from you or come from different backgrounds. And this is an opportunity for us to address just how critical it is to interact respectfully with them. As we fill out people's forms and help them throughout the day, we might find we don't always understand the choices that people have made in their lives or how they choose to interact with us, and that is okay. Our job is to approach the situation respectfully, positively, and in a culturally competent way. I really like this graphic of the cultural iceberg. It's from Edward T. Hall, and there are elements of surface culture that are specific to where people are from, that are outwardly visible. And then there's what we call deep culture, which addresses everything from attitudes towards family, work, cooperation, religion, marriage, etc., courtesy, manners, body language, tone of voice,
gestures, eye contact. All of these can be totally different depending on who you're working with, and your actions may be interpreted differently by the folks that you are working with as well. It's also super important that we recognize at a citizenship clinic power dynamics. People may come into the clinic confused about the process of applying, about the rules, and this puts them in a position of pretty necessary vulnerability because we're the ones who are serving them. So depending on our background and our position in relation to the applicant, this may be more or less pronounced. Power dynamics manifest themselves in many ways, but some things to think about are who depends on who for what? Is this available from somewhere else? At what cost? Whose cooperation is essential? Whose cooperation is useful but not essential? What are the dynamics of the culture? And then finally, how does my privilege and position affect my interactions or my understandings of this person and their experiences? So you may be working with someone whose race, class, language, culture, gender, age, ability, sexuality would be different from yours, and will create kind of a different recipe of power dynamics between the two of you. Attitude is everything when it comes to cultural competency. You want to be positive, smile often, and be patient with the person. It's contagious, and what comes from the heart reaches the heart. The most important thing that we want to avoid, we don't want people to feel like they're difficult or they're a burden. We really want to avoid making any type of disparaging comments, reactions, judgments about things such as how many children someone has, marriages they may have, how old they are, ability to speak English, any other choices they may have made in their life regarding, the immigration system, interactions with the criminal justice system, all of those things. This is not our place to judge them in any way. You really want to approach everyone with an attitude of humility, non-judgment, and acceptance of difference. People come to these citizenship workshops trusting us with some of their most personal and private information. So we need to be cognizant and sensitive to that. We're not there to judge any choices they may have made or anything that may have happened to them. I also want to mention something called compassion fatigue, also known as burnout. This is something that you might experience as a volunteer in just one workshop, or could be something that you run into after having volunteered many times. It's often described as the cost of caring for others who are in emotional or physical pain. It's characterized by emotional exhaustion and a pronounced change in your ability to feel empathy for the folks that you're helping, and also for your loved ones, coworkers, friends. This is super normal, and your feelings are valid. For some of us, when you're hearing other people's experiences, traumatic experiences, that might trigger difficult memories of your own experiences. So some common symptoms of compassion fatigue might include chronic exhaustion, reduced sympathy or empathy, feelings of anger, isolation from others, poor satisfaction with your volunteer experience, hypersensitivity, and difficulty sleeping. So some tips to overcome compassion fatigue and practice some self-care as a volunteer. Ground yourself in the moment. Take a little walk around. You can feel free to let the person know if you've had a difficult experience with an applicant, maybe hearing a really traumatic story or something that they've been through, to take a walk, take a breath, go get a snack, speak to someone else who will validate you. There are other volunteers who may be feeling the same way that you can connect with. Remember why you decided to volunteer in the first place. journal, make a gratitude list. There's lots of different ideas. And of course, you can reach out to us if you want more additional resources on this, and we're happy to provide those. Last few reminders, make sure that you pay attention to your email. Your site coordinators are going to send out important updates as your workshop approaches. If you have to cancel for any reason, just let your organizers know as soon as possible. People who don't show up really kind of throw off the whole plan for the day. And then finally, you'll likely have a day of volunteer orientation. Please make sure to attend that. Finally, we want to thank you for taking the time to volunteer and to get yourself educated and prepared to be effective. After filling out their citizenship application with you at a workshop, applicants wait anywhere between 6 to 18 months until they get an interview with USCIS. That's where they answer questions about their application. That's where they take the naturalization test. And we wanted to share photos with you. These are 3 people, Kim, Martina, and Suhey, who have attended citizenship workshops in the past, and they sent us these photos of themselves after they passed their oath, ceremony, and interview. So what you do really changes people's lives, and we are very grateful for your support.